A federal judge has temporarily blocked President Trump's plan to offer incentives for federal workers to resign just hours before they faced a midnight deadline.
Fox 5's Linda Schmidt live in the newsroom with the latest developments out of Washington. Linda.
Yeah, good evening to both of you. And you know the developments every day, they are ever changing. There have been some questions, though, as to whether the president's buyout offer to federal workers is even legal. Several labor unions are suing, and now a judge has temporarily blocked that plan. Now, the president wants to downsize the government. The deadline was midnight tonight for federal employees to decide if they wanted to take that buyout. They would resign and they would get pay and benefits through September. However, a U.S. district judge in Boston scheduled a hearing on this for Monday and pushed back the deadline until after that hearing. In another development today, President Trump speaking at a prayer breakfast in Washington, announcing that he is creating a, quote, freedom of religion commission, as well as a task force to deal with what he calls anti-Christian bias in the U.S. He claims the federal government has been weaponized.
What's happening, friends? Welcome to Jack Mockler. Right now, the courts are not just ruling against Trump, they are dismantling his core agenda piece by piece, with conservative and liberal judges alike accumulating a record of legal defeats that no amount of spin can disguise. When a Reagan-appointed judge calls a sitting president uniquely dangerous and warns that attacks on the judiciary threaten constitutional governance, that is not political rhetoric, but a judgment from inside the legal establishment about the nature of the crisis the country is facing. The legal system is not designed to force a president out of office through judicial rulings alone. Courts do not have that power. A federal judge cannot order a president to resign. But what the courts can do, and what they are doing with increasing frequency and force.
Trump is signing an executive order putting Attorney General Pam Bondi in charge of the task force at the Justice Department.
The mission of this task force will be to immediately halt all forms of anti-Christian targeting and discrimination within the federal government, including at the DOJ, which was absolutely terrible, the IRS, the FBI, terrible, and other agencies. In addition, the task force will work to fully prosecute anti-Christian violence and vandalism in our society and to move heaven and earth to defend the rights of Christians and religious believers nationwide.
And for the second time in just 2 days, another federal judge has blocked President Trump's birthright citizenship order. A judge in Seattle today criticizing the president, saying that he is trying to change the U.S. Constitution by signing an executive order that would end citizenship for children of parents who are in the U.S. illegally. So a lot going on today. Steve, back upstairs to you.
Is systematically dismantle the legal architecture that the administration has been using to implement its most ambitious and controversial agenda items. One policy at a time, one ruling at a time, one judicial intervention at a time, the courts are establishing that the specific legal authority the administration claims for its actions does not exist in the law or the Constitution as the administration has interpreted them. The cumulative effect of that dismantling is not a legal requirement for resignation. It is a political and moral environment in which the argument that this president is governing within the law and within the constitutional limits of his office becomes increasingly hard to sustain.
Tonight, just hours ahead of the White House deadline, a federal judge has paused the Trump administration from implementing its buyout program for all federal workers. That buyout offer, part of the president's campaign pledge to save taxpayer money by slashing the federal workforce. But labor unions went to court to block it, arguing it violated multiple laws. And now that judge has put the buyouts on hold until Monday. A senior administration official says more than 60,000 federal employees have accepted the offer. That represents more than 2% of the federal government's civilian workforce. Officials here previously said they expected 5 to 10% to take the buyout.
What President Trump and Elon Musk and this entire administration is trying to do is make our bloated bureaucracy here in Washington run like a profitable business.
And tonight, the Trump administration is ramping up pressure to take the buyout. An email to all eligible federal workers obtained by NBC News warns those who do not could lose their jobs. Reading in part, "At this time, we cannot give you full assurance regarding the certainty of your position."
And that political and moral environment is where the concept of inevitability lives, not in the legal mechanics, but in the political and moral accounting of what the courts are collectively saying about this administration's relationship to the rule of law. Tonight, Just hours ahead of a critical White House deadline, a federal judge has paused the Trump administration from implementing its controversial buyout program for all federal workers. This is not a minor administrative hiccup. This is a direct judicial intervention into what the administration has characterized as one of its core strategies for reshaping the federal government. The buyout offer, part of the president's campaign pledge to save taxpayer money by slashing the federal workforce, was presented to hundreds of thousands of federal employees as a fork in the road.
The president today touting progress on his pledge to slash spending.
We got rid of woke over the last 2 weeks.
And praising Elon Musk and his Department of Government Efficiency, including its effort to dismantle USAID that distributes billions of dollars in foreign aid.
They can't believe they're getting caught, and I have great respect for the people that are doing it. Elon Musk is helping us on it, and he's pretty good.
Tonight, the Washington Post reports DOJ employees have gained access to highly restricted government records on millions of federal employees, including Treasury and State Department officials in sensitive security positions, according to 4 U.S. officials with knowledge of the developments. And the White House confirms a DOJ staffer approved by a federal judge to access Treasury Department payment systems has resigned after the Wall Street Journal asked about his links to a deleted social media account that advocated for racism and eugenics. Meanwhile, federal workers tonight are in limbo. Alfonso McCree accepted the buyout offer.
Accept the buyout and receive pay through a specific date, or face an uncertain future under an administration that has made no secret of its desire to purge the professional civil service of those who might resist politically motivated directives. But labor unions went to court to block it, arguing that the program violated multiple laws governing the federal workforce. And now that judge has put the buyouts on hold until Monday, creating a legal pause that has thrown the entire program into chaos. The numbers involved are staggering. A senior administration official says more than 60,000 federal employees have already accepted the offer. That represents more than 2% of the federal government's civilian workforce. Officials here previously said they expected 5 to 10% to take the buyout, but now those numbers are in legal limbo. Caught between the administration's desire to radically restructure the federal bureaucracy and the judiciary's determination to ensure that such restructuring happens within the bounds of the law. What President Trump and Elon Musk and this entire administration is trying to do is make our bloated bureaucracy here in Washington run like a profitable business. That is the stated goal. But the legal system is pushing back hard, asking whether the methods being used to achieve that goal are consistent with the statutory and constitutional limits that Congress has enacted precisely to insulate the professional government workforce from political manipulation. The significance of the judicial intervention in the civil service program extends far beyond the specific buyout offer itself. This program was not a marginal administrative initiative. It was central to the administration's strategy for reshaping the federal civil service in ways that would outlast any single term and that would alter the fundamental relationship between the executive branch and the professional government workforce that implements its policies. The legal challenge to that program and the judicial intervention that temporarily blocked it and signaled deep legal concern about its structure and purpose was therefore not just a ruling about a deferred resignation offer. It was a ruling that implicated the administration's entire approach to using the powers of the executive branch to reshape the institutional government in ways that critics argued crossed the line between legitimate management of the executive workforce and the illegal purging of civil servants based on political considerations. When a court blocks something that is central to an administration's core agenda, the political implications go far beyond the specific program being blocked. The specific legal concerns that courts have identified in the civil service program and in other Trump executive actions reflect a consistent pattern that legal analysts have been tracking across multiple policy areas, a pattern of using the administrative and executive powers of the presidency in ways that push against or past the statutory and constitutional limits that define those powers. The deferred resignation program raised questions about whether the administration had the authority to structure a buyout offer in the way it was structured, and about whether the conditions attached to the offer were consistent with the civil service protections that Congress has enacted, and about whether the purpose of the program, which critics characterized as a mechanism for eliminating employees who might resist politically motivated directives, was consistent with the legal framework governing the management of the federal workforce. These are specific legal questions, and the courts examining them have not been gentle in their assessments of the administration's legal arguments. The language of deep legal concern that has characterized the judicial response to the civil service program mirrors the language of multiple other rulings across multiple policy areas. The emergency powers cases, the immigration enforcement cases, the cases about the use of federal agencies in ways that critics argue exceed their statutory mandates. The pattern is consistent, and the accumulation of consistent patterns across multiple courts and multiple policy areas is what produces the feeling that the legal system is drawing a hard line. This is not a rogue judge acting on partisan impulse. This is a judiciary that is systematically and consistently finding that the administration's legal theories do not hold up under scrutiny. And that systematic finding is what is producing the catastrophic framing that now saturates political media. Every administration faces legal challenges. Every president has policies blocked by federal judges. The normal pattern is for the administration to appeal, for the legal process to work its way through the court system, and for some policies to ultimately survive while others are struck down with the overall balance depending on the specific legal merits of the specific arguments being made. What is different about the current moment is not the existence of legal challenges or even the frequency of adverse rulings. It is the specific nature of what is being struck down and what the pattern of adverse rulings reveals about the legal foundation, or lack thereof, of the administration's approach to governing. When courts consistently find that the administration is claiming authority that the statutes do not grant, that the emergency powers being invoked do not authorize the actions being taken, that the constitutional limits on executive power have been exceeded in specific and documented ways, the pattern is telling you something about the approach to law and executive authority that the administration is taking. And what it is telling you across multiple courts in multiple cases in multiple policy areas is that the administration has been systematically operating on a theory of presidential power that does not reflect the law as it is actually written and as the courts are actually applying it. The civil service program controversy illustrates this pattern in a particularly clear and instructive way. The program was structured in a way that raised specific and serious legal questions that any competent administrative lawyer reviewing it in advance would have identified. The legal concerns were not obscure or technical. They were fundamental questions about the authority of the executive branch to structure a buyout offer in ways that potentially circumvented the civil service protections that Congress has enacted precisely to insulate the professional government workforce from political manipulation. The courts that examined those questions did not find them difficult or close. They found them serious enough to justify immediate intervention. Serious enough to temporarily block a program that the administration was trying to implement on a very tight timeline in ways that the administration argued were essential to its ability to reshape the federal workforce quickly. The speed and the severity of the judicial intervention tells you something about how the courts assess the legal merits. When a judge moves quickly and speaks in the language of deep legal concern, rather than the language of careful deliberation between competing reasonable interpretations, the judge is communicating a specific assessment of the quality of the administration's legal argument. And the assessment being communicated about the deferred resignation program was not favorable. The broader context of judicial skepticism toward the administration's legal theories is something that extends well beyond the civil service program and into the full range of executive actions that the administration has been taking since the beginning of its second term. The emergency powers cases, the immigration enforcement cases, the regulatory policy cases, the personnel decisions cases, the use of federal agencies in ways that critics argue exceed their statutory mandates. Across all of these domains, courts have been consistently and repeatedly finding that the administration is claiming authority that the law does not support. The sheer volume of adverse rulings, the number of times that courts across different jurisdictions and different levels of the federal judiciary have looked at specific administration actions and found them legally deficient is itself significant data. It is a pattern that cannot be attributed to the ideological bias of a single judge or a single circuit. It reflects a widespread judicial assessment that this administration's approach to the law is fundamentally unsound in ways that courts across the spectrum are identifying and acting on. The role of conservative judicial voices in that pattern is worth emphasizing because the credibility of the judicial critique of Trump's approach to the rule of law depends significantly on whether it comes only from judges appointed by Democratic presidents or whether it includes the voices of conservative jurists whose legal credentials and institutional standing are beyond partisan challenge. Judge Mark Wolf, a federal district court judge appointed by Ronald Reagan, a judge whose conservative legal credentials are unimpeachable and whose institutional standing within the legal establishment is beyond serious partisan challenge, has made public statements that are remarkable for their directness, their severity, and their specificity about what concerns him. Wolf has called Trump uniquely dangerous, not just wrong on policy, not just legally overreaching in ways that courts can and should correct, but uniquely and distinctively dangerous in a way that sets this presidency apart from others that have tested constitutional limits. He has specifically cited Trump's attacks on judges, the public campaigns of intimidation against members of the judiciary who rule against the administration, the questioning of judges' legitimacy and patriotism, the express willingness to disregard rulings the administration disagrees with as the basis for that characterization. Wolf's concerns, as he has articulated in multiple public forums with his name attached and his full institutional credibility behind it, is not about the outcomes of specific cases or about specific policy disagreements between the executive and the judiciary. It is about the foundational question of whether a president who attacks the legitimacy of the judicial branch, who treats court orders as optional suggestions rather than binding legal requirements, and who has communicated a willingness to simply proceed with policies that courts have found unconstitutional, is compatible with the basic requirements of constitutional governance in a country that has operated under the rule of law for over 200 years. That is a profound and specific legal and constitutional concern, and it carries weight precisely because it comes from a conservative jurist, someone with no ideological stake in the liberal critique of Trump, and whose credibility in the legal establishment is not dependent on partisan alignment with the Democratic opposition or with the progressive legal movement that has consistently opposed the administration's agenda. Wolf's public statements are the most visible example of a conservative judicial voice making an explicit and severe critique of Trump's conduct. But they are not the only example. Across the federal judiciary, judges appointed by Republican presidents have been among the most pointed and most legally significant voices in the assessment of the administration's legal claims. The Supreme Court rulings have included the votes of conservative justices appointed by Trump himself. The various rulings blocking specific executive actions have included findings by Republican-appointed judges that the legal arguments being advanced by the administration are not viable. This is not a partisan pattern of judicial skepticism. The fact that the critique of the administration's approach to law is not limited to liberal judges but includes conservative ones is what makes judicial intervention in this period something more than ordinary partisan conflict dressed up in legal language. It is a professional assessment by legal minds across the ideological spectrum that the administration's theory of its own power is not supported by the law. The emergence of conservative judicial voices as some of the most pointed critics of Trump's approach to the rule of law is one of the most significant and most underappreciated developments in the legal and political landscape of this period. When judges who were appointed by Republican presidents who share the conservative legal philosophy that has dominated the judiciary for decades begin to speak out publicly and forcefully against the administration's conduct, it signals something fundamental about how the legal establishment views this presidency. It signals that the concerns are not partisan. They are institutional. They are about the survival of the constitutional order itself. And those concerns, once articulated by voices with the credibility and institutional standing of a Reagan appointee like Wolf, are very difficult to counteract through political messaging alone. The gap between the legal reality of what the courts are doing and the political narrative that describes it as resignation-inducing is real and worth being honest about, because conflating the two does a disservice to understanding what is actually happening and why it matters. No single court ruling legally requires Trump to resign. No ruling has created a formal legal mechanism for his removal that does not already exist through the constitutional processes of impeachment and conviction or the political processes of electoral defeat. What the rulings are doing is something different and in some ways more significant. They are systematically dismantling the legal architecture that the administration has been using to implement its most ambitious and most controversial agenda items. One blocked policy at a time, establishing in each case that the specific legal authority claimed for the specific action does not exist in the law or the Constitution as the administration has interpreted. The cumulative effect of that dismantling is not a legal requirement for resignation. It is a political and moral environment in which the argument that this president is governing within the law and within the constitutional limits of his office becomes increasingly hard to sustain. The political implications of sustained, deep, nonpartisan judicial skepticism toward the administration's core legal theories are significant in ways that go beyond the specific policies that get blocked in any individual case. Presidential governance depends at a fundamental level on a degree of legal credibility, on the ability to assert that the actions being taken are within the authority that the Constitution and the law grant to the executive branch, and to have that assertion treated as plausible by the courts and by the legal establishment more broadly. When that credibility is repeatedly and publicly challenged, when courts across the ideological spectrum consistently find that the claimed authority does not exist in the form asserted, the political cost is real, even when the specific legal consequences of any individual ruling are limited. Partners and allies abroad who need to assess the durability and the legal validity of American policy commitments take note of repeated judicial findings against the administration's legal theories. Members of Congress, including members of the president's own party, who need to make their own assessments of whether supporting the administration's agenda is legally defensible, take note. Career government officials who need to decide whether specific directives they are being asked to implement are lawfully authorized, take note. The accumulation of adverse rulings does not just block specific policies. It shapes the entire environment within which the administration is operating, and it does so in ways that make the political and institutional cost of continued governance under a legally challenged theory of executive authority progressively higher. The catastrophic ruling narrative that has emerged in political media captures something real about the political and moral trajectory even when it overstates the legal mechanics. Resignations in American political history have rarely been driven purely by legal requirements. They have been driven by political calculations, by the assessment that the political cost of continuing has become higher than the political cost of leaving, that the institutional support necessary for effective governance has eroded to the point where continuing is no longer viable, that the moral and reputational damage being done by continued fighting against an accumulating set of adverse judgments outweighs whatever benefit might come from staying the course. Nixon did not resign because the law required him to. He resigned because the political calculation, the assessment of the institutional support available to him after the Supreme Court ruled against him on the tapes and Republican congressional leaders told him the votes for conviction were there, made resignation the rational choice. The catastrophic ruling narrative is essentially applying the same logic to the current moment, asking whether the accumulation of adverse judicial rulings, conservative judicial critiques, blocked policies, and legal credibility erosion has created a political environment in which the rational choice for a president who cares about governing effectively rather than merely surviving politically is to reconsider whether continuation serves any purpose that resignation would not equally serve or better serve. The catastrophic ruling narrative captures the system finally catching up with a presidency that assumed executive power was unlimited, but across multiple courts and cases, the consistent finding is that limits are real and apply even to this president. The accumulation is unprecedented. A criminally convicted sitting president, a signature economic policy struck down, a civil service program blocked, immigration enforcement generating contempt findings, and a former attorney general facing perjury accusations. This combination across criminal, civil, administrative, and constitutional domains simultaneously has no modern precedent. The second thing to understand is what the continued accumulation of adverse legal judgments does to the administration's ability to achieve its substantive policy goals, to actually accomplish in concrete terms the changes to the country that the political program is designed to produce. Executive power is most effective when it operates in an environment of legal credibility, when the actions taken are presumed to be within the authority of the office, and when the institutional system processes those actions without constant interruption by judicial interventions and legal challenges that delay implementation, create uncertainty, and require the diversion of political and legal resources from policy accomplishment to legal defense. When that credibility is consistently challenged, when every major initiative faces immediate and serious legal challenge that courts take seriously enough to block or scrutinize, the effective exercise of executive power becomes substantially more difficult than the formal powers of the office would suggest. The administration can take actions, but the actions are constantly being interrupted, delayed, and in some cases reversed by a legal system that has consistently found the administration's legal arguments wanting. That constant interruption is itself a form of political and governance cost that accumulates over time. The third thing to understand is what the specific language that conservative judicial voices are using to describe this administration's approach to the rule of law signals about the long-term assessment of this presidency within the legal and institutional establishment that any president ultimately needs to be able to operate within effectively. When Judge Wolf says Trump is uniquely dangerous and identifies his attacks on the judiciary as a specific threat to constitutional governance, he is not making a partisan political argument. He is making an institutional argument, an argument about the conditions that constitutional democracy requires to function and about whether this specific president's conduct is compatible with those conditions. That institutional argument, made by conservative jurists with the credibility that lifetime appointment and decades of service confer, is the kind of argument that shapes how future historians and future legal scholars will assess this presidency. It shapes how law school classes will discuss this period. It shapes the professional consensus in the legal community about what happened and what it meant. And it is an argument that, once made by voices with Wolf's credibility and institutional standing, is very difficult to counteract through political messaging alone. The future trajectory of the legal and political situation depends on a set of variables that are genuinely uncertain: the pace and outcomes of the ongoing cases in multiple courts, the results of congressional oversight proceedings, the decisions that key figures are making about their own legal positions, the political dynamics within the Republican Party as the cumulative weight of the legal challenges becomes more visible and more politically costly. But the direction is clear. The legal system is not going to stop asking hard questions about whether this administration's actions are within the authority the law grants. The courts are not going to stop blocking policies that they find legally deficient. The conservative judicial voices that have publicly broken with the administration's approach to the rule of law are not going to retract those assessments. And the accumulation of all of these elements, the blocked policies, the adverse rulings, the credibility costs, the conservative critiques, the oversight pressure, creates a legal and political environment that is progressively more constraining and progressively more costly for an administration that is simultaneously fighting on multiple legal and constitutional fronts. The resignation inevitability framing that surrounds the catastrophic ruling narrative is worth examining carefully because it captures something real about the political and moral trajectory even when it overstates the legal mechanics. Resignations in American political history have rarely been driven purely by legal requirements. They have been driven by political calculations, by the assessment that the political cost of continuing has become higher than the political cost of leaving, that the institutional support necessary for effective governance has eroded to the point where continuing is no longer viable, that the moral and reputational damage being done by continued fighting against an accumulated set of adverse judgments outweighs whatever benefit might come from staying the course. The catastrophic ruling narrative is applying the same logic to the current moment, asking whether the accumulation of adverse judicial rulings, conservative judicial critiques, blocked policies, and legal credibility erosion has created a political environment in which the rational choice for a president who cares about governing effectively rather than merely surviving politically is to reconsider whether continuation serves any purpose that resignation would not equally serve or better serve. The accumulation of adverse rulings from both conservative and liberal judges, including Reagan appointees, is systematically dismantling the administration's agenda and eroding its credibility. The silence around sealed grand jury testimony compounds the uncertainty, as Trump cannot know whether his most trusted ally chose to protect him or himself. The ultimate political consequence, whether resignation, electoral defeat, impeachment, or some other reckoning, will be determined by the choices made as this pressure continues to build, but the direction is clear. The system is finally and seriously catching up with a presidency that assumed executive power was essentially unlimited.